Testimony from earlier today in the Timothy Coggins cold case murder trial out of Georgia. It's a case where that victim, Timothy Coggins, was apparently stabbed and dragged behind a vehicle by two defendants. That's the accusation. It took prosecutors all this time to catch up to the two proper people. The defense says the state botched the case when it was live back in the 1980s, and that the state really shouldn't be pushing forward with rumor and innuendo testimony linking the two defendants to the case. Only one defendant is on trial right now. The second defendant will have his day in court someday. The prosecution promised the jury on opening statements. Gary Gerstenfield is back with us here on the Law and Crime Network. He's a trial attorney in the Washington, D.C. area to talk about this case. Gary, good to see you.
Good to see you, Aaron.
Okay, so what do you make of this case? 30-some years after this poor victim's death, we have this trial, and we've got a lot of evidence that the prosecution says was neglected, was lost over the years, but the prosecution is trying to hang its hat on statements that this defendant made over the years, which suggested he knew a lot more about this case than what was made public. Is that enough to link this defendant, Frankie Gebhardt, to the death of Timothy Coggins?
Well, it's a tough case for the prosecution. I'm not saying they can't make it, but they don't have DNA, they don't have any eyewitness testimony, and they are correct in saying there was a botched prosecution. Maybe that prosecution was a lack of energy and maybe a lack of a desire in actually, proving what happened. But whenever you have a case where you've got a botched prosecution from the beginning and now you have basically a second shot, it does give the defense lots of opportunities.
It does, and it's an interesting case because rarely do I see a case where a prosecutor gets up there and bashes the investigators who are the ones that piece the case together. But going back and listening to some of this on the stand this afternoon, I can understand why they did it. They said that perhaps the investigation itself was racially biased back then.
Yeah, they're making an argument basically that this was a case where the white supremacy and racial prejudice was not just in the hearts and minds of the perpetrators, but also in the minds of those charged with the responsibility of bringing the people to justice who did it.
Exactly. Look, it certainly turned into a colorful case thus far. We've had some really interesting testimony here. And so many pieces of evidence that we're hearing about that we just really wish we had. Apparently, there were the hairs of some Caucasians found on the victim's clothing. And of course, these days we can try to pull DNA out of those hairs. If we only had them, we would have a much clearer answer in this case. So look, I mean, what's going on with the evidence storage? We've got other states where evidence is kept in storage for decades. Apparently in Georgia, this stuff gets lost, or at least it did in this case.
Well, I think what happened after, first of all, the investigation was closed out after a couple months. So clearly, I think it's recognized that there was not much enthusiasm in prosecuting this case. And I suspect that, this evidence, whatever they had, was sort of thrown in a box and thrown up on a shelf and left to kind of fester for 35 years.
Yeah, certainly we're going to wait and see how this all rolls out as testimony continues. Just want to let everyone at home know that this case is on pause until tomorrow. They are done for the day in the Georgia prosecution of Frankie Gebhardt. We're going to listen to some previous testimony in this case, though, because the victim's sister, Teresa Coggins, was on the stand today early on in the case. Here's some of what she had to say on the witness stand. We're going to break out of that emotional testimony from the Timothy Coggins case out of Georgia. That's the cold case that we're covering, which is finally up on trial after 30-some years from the victim's death, because there is a witness on the stand that may be the key witness for the state in the so-called Marine murder trial out of Lexington, Kentucky. Again, this is the case where U.S. Marine Corporal Jonathan Price and his wife were shot outside a Louisville area bar as they were out celebrating the wife, Megan Price's birthday. Megan Price survived and testified. Jonathan Price died right there at the scene. The state in that case is saying that the key link between the two defendants who are being tried together and the murder is a gun. And they believe that the defendants took the gun 6 days before the murder from a hotel room where a number of people were robbed who were there in town to attend a gun show. That's where they think the gun came from that was used in the Price murder. and they're trying to get the connection made by ballistics. There is a firearms expert who just took the stand in that case a few minutes ago. We're going to dip in as his testimony is in progress. And yet again, it looks like a sidebar here in the Marine murder case out of Lexington, Kentucky. This is the case of the death of Jonathan Price. He was a U.S. Marine corporal who was out celebrating his wife's birthday when he and his wife were sitting in a parking lot waiting for friends to arrive to a local bar. While they were sitting there, two African-American men approached, demanded money. They started roughing up the wife a little bit, trying to get the purse away from her. Jonathan Price decided to fight back, took one of the suspects to the ground, and ultimately, it resulted in Jonathan Price's death. A shot went off and hit him right in the heart. Gary Gerstenfield is an attorney in the Washington, D.C. area. He's joining us here on Law and Crime. Let's talk about this case a little bit, Gary. We finally have this forensic firearm examiner, this firearm expert on the stand, and this is the key link that prosecutors really need to try to seal this up.
Yeah, to connect the dots.
Mm-hmm. Because ultimately they're saying, hey, look, you know, this weapon was stolen from a hotel room. It was missing for about 6 days. Then they believe it was used in this murder, but they didn't wind up getting their hands on the weapon until later when a criminal informant approached the Department of Alcohol, Tobacco, and Firearms, the federal ATF that is, and said, oh, somebody's trying to sell a gun. Can I line up a buy with you folks? And then the ATF lined up a buy. The criminal informant claimed that the seller was trying to sell it on behalf of someone else, but nobody knows who. Ultimately, the person from whom they purchased the gun clammed up and refused to cooperate with anybody, refused to cooperate with the ATF, refused to cooperate with the local police in the murder of Jonathan Price. So the big question is the gun that was just shown in court the actual murder weapon? There's some discrepancies there between testimony from the wife, who said that the gun that she saw brandished that evening had a silver barrel. This gun is black all the way through and through. How do we try to separate this out?
People see what they want to see. I mean, this is something that happened very quickly. There's no real understanding how much Megan knows about guns. The fact that she saw a gun is probably more of what she remembers. And sometimes even a black gun can appear silver because the way light is shining against it. And of course, all this is happening while her husband, Jonathan, is being shot. So live testimony, particularly about a handgun itself, is not the most exacting form of testimony that you're going to come across.
Yeah, look, I mean, when we watch the surveillance video that doesn't show the shooting directly, but which shows what's going on in the area, this thing was over in a matter of seconds. I mean, it was over in probably less time than it took me to lay out the basic facts just a couple of seconds ago. But, you know, she was pretty clear that she couldn't identify either of the two suspects because she didn't get a good look at them. But she said the gun had a silver barrel, and I'm wondering, could that be a fatal flaw in the state's case here? Or is the state going to turn around and do some experiments with light and show some photos of the gun in different lights and say, hey, look, you know, light can reflect off this. It's still a metallic object. At 1:30 in the morning, maybe it could look like a silver gun if somebody sees it in just a split second in a chaotic situation, and maybe she was not mistaken at all. Maybe we should trust the ballistics reports here.
Well, of course, what you're doing then is you're trying to speculate, and you're trying to sort of get trying to explain a difference in color. For example, there was a case that you all did about how an automobile at night, with the light from an overhead light casted, made the color of the vehicle look different, and they try to use that as an explanation as to why an eyewitness picked out a different color of the vehicle than the one they actually thought was used in the crime. It's the same thing here. You're trying to explain why a witness is making a bad identification of something like a gun. Ballistics, it's one of those things that some people call it junk science. Some people believe it's valid science. Certainly against the gold standard, of course, is DNA evidence. But whenever using anything other than DNA, there's always a way to challenge the credibility of the expert.
Yeah, I mean, one of the ways that this is attacked, and we've seen trials with this, is because it's a science that's based on human observation. You know, an analyst has to look at the bullets under some kind of a microscope or some kind of an enlarging lens and say, yeah, this one looks like this one, and that suggests to me that they were fired out of the same exact gun because the gun would leave similar marks. You know, is that enough for the jury to really latch on to and believe? Or is it just, well, I don't know. I mean, I think that one pen looks like another pen.
I think overall, I think this is a troubling case for the state, because even if they can prove that, you know, to the satisfaction of a jury that this gun was actually used in the killing of Jonathan, I'm not sure that that necessarily is going to be the linchpin that the defendants charged are the ones that actually committed the crime, because again, there's no actual identification of them being the shooters, and there's no confession, and there's a lack of any real strong evidence that connects them to the gun.
Yeah, this sidebar is grinding along, Gary. It seems to be my opinion, and perhaps yours too, that since we have heard no objections in this case, that it seems that the judge who's presiding over it prefers to have the objections handled during a sidebar. In other words, one of the attorneys says, Your Honor, may we approach? And that's all the jury hears, and it's all we hear. We don't hear this argued out fully in court. It appears that that's the process that's going on right now. So we're going to take a quick break here on Law and Crime. We'll be right back with more analysis of the Marine murder case out of Lexington, Kentucky in just a couple of minutes. We're back here on Law and Crime talking about the murder of U.S. Marine Corporal Jonathan Price, who was shot and killed while he was out celebrating his wife's birthday. The wife was injured. She survived to testify. And one of the key pieces of evidence in this case is, of course, the gun that was used during that robbery, which turned into a murder. Gary Gerstenfield is here with us on Law and Crime to talk about it a little bit. And Gary, the reason we're taking a pause right now is because testimony is at a pause and there's a lengthy sidebar here. I'm always curious to exactly what the objection is, because oftentimes in this case it's not quite jumping out at me exactly what the issue is with what the witness had said. It's a little bit of a secret. Oftentimes I can usually pick it out.
Well, in this case, the problem is normally when you want to bring in scientific evidence, you should have a motion in limine to kind of hash out all of the issues so that the trial progresses more smoothly. Here it appears that the judge wants to argue these issues as they come up, as opposed to having a lengthy motions process prior to the trial.
Yeah, you know, and I always wonder what's going on in these cases, because oftentimes we don't get a clean look at what has been filed before we jump into a trial. But let everyone know, a motion in limine, of course, is a motion that an attorney files about a piece of evidence or a piece of testimony that's expected. And it basically asks the judge to make a ruling on that piece of evidence before you get to trial. So everybody knows this is in or this is out. And these are really critical motions, because oftentimes they're up there with a suppression hearing. In other words, a hearing to try to suppress something that was gathered, or a piece of testimony that's being proffered because it was gathered in violation of a constitutional right or something like that. A motion in limine is just as important, Gary.
Right. A motion in limine is where you're challenging, from the defense point of view, or I guess even the prosecutor point of view, what you're trying to do is you're trying to establish whether this piece of evidence is going to be available for the jury. And it helps frame exactly how you're either going to prosecute the case or how you're going to defend the case. Oftentimes, motion in limines, if you're successful in a motion in limine as a defense attorney, that sometimes can be the doom of the prosecutor's entire case. So winning a motion in limine can be huge as a strategic measure for the defense.
I've sat and written objections to many of them in the past, and none that you wrote, Gary. We've never been adverse. but look, this is grinding along, folks. This is turning into a lengthy sidebar. We presume it's over some kind of an objection to evidence, because it popped up right when this gun was coming out into court and right when this witness was about to talk about it. So just to get you caught up to speed on some of the other testimony in this case, we're going to play this for you, and we'll be right back. Those are the key facts in the Marine murder trial that we're covering live out of Lexington, Kentucky. Gary Gerstenfield is still with us here on Law and Crime. Gary, I want to talk a little bit about some of the earlier testimony here. Megan Price survived this attack. She got up on the stand. Many things can be said about her testimony. One of the things is heartbreaking. She's up there recalling this evening when they were out to celebrate, and it changed in a split second. It turned into an attack. It turned into the husband trying to defend her and himself, and then it turned into a gunshot right straight to the heart for that husband.
Yeah, he was able to get he was able to get he was able to take down one of the he was able to take down one of the attackers, and then the other one pulled a gun and killed him.
Yeah, and she's up there recalling it, and in the process of recalling it, she had her husband's military name tape on the blouse that she was wearing in a remembrance of him. You know, clearly she was sad. She was trying to recall things as best she could, but I think her testimony was very, very credible, not just because she was there, but because she was careful to separate what she did remember and what she didn't remember. And I think that added to her credibility. She didn't get up there and just try to blame everyone and everything that the state put in front of her.
Yeah. Yeah, very much so. This is a case where she's being honest about what she saw and honest about what she experienced. And that's a problem for the prosecution because, as you pointed out earlier, Aaron, this happened so quickly. It began, you know, her husband is killed. It all happened so quickly and it's over. And it's hard in the moment to really, you know, to even appreciate exactly what's happening as it's happening, much less be in a position to have really good recall.
Yeah, and look, it's such a hard case to try to wrap our heads around, because looking at it from a perspective of reasonable doubt, you know, there's a lot of little pieces that suggest, well, you know, is there enough of a state's case to result in a conviction, and a conviction that could lead to a possible death penalty in this case, because that's on the table in this state, and it's on the table in this trial, but also, you know, is it strong enough, in other words, or do all these little pieces, which on their own would just be little nuggets of information, do they add up? You've got a gun that was taken from a hotel room. It's believed to be the gun that was used in this crime. You've got the defendants in the neighborhood at least 13 minutes before it happened, because they were spotted driving a car that was caught on surveillance video. The license plate number is clear. The person who owned the car said that these two borrowed it. Their phones are in the area. You know, it starts to add up, and we wonder, is it enough? But look, testimony's looking like it's picking back up again. Again, this is the forensic expert. Let's go back to court now live. We had a brief break in testimony there in the Marine murder case out of Lexington, Kentucky. Again, Jonathan Price, 26 years old, was shot right through the heart outside a bar in Lexington, Kentucky, where he was celebrating his wife's birthday. He was attacked by two African-American men, rather. His wife indicated she and her husband were attacked, and in the process, the Marine corporal tried to fight back. The issue resulted in the scuffle with the two, Jonathan Price and at least one of the attackers, landing on the ground. That's when the shot went off. Gary Gerstenfield here with us to talk about this case. Gary, a really strong cross-examination there about this Springfield XDS. That's the weapon that you just heard that firearms expert try to link back to this murder of this U.S. Marine corporal, and a lot of cross-examination about whether or not the science of matching the bullet or the casing to the gun from which they believe it was fired is junk science, in other words.
Yeah, well, I mean, I think it kind of is junk science. I'm looking at the two pictures of these bullet casings. I can't tell what I'm looking at. And one of the points I think the defense did a real good job is saying, well, wait a moment, why does it take years of experience to be able to look at two things and say they look alike or they don't look alike? Why do you need all this specialized training, and why do you have to go to the gun manufacturers to see exactly how they manufacture guns so you can look and see whether or not the scrapes and bumps and bruises on a bullet casing matches a specific gun?
Yeah, you know, and look, there was another really interesting point of this cross-examination right near the tail end, where the expert talked about reports of accidental discharges of this type of weapon. So where is the defense going with this? It seems to me that they're trying to say, well, it's not the weapon, members of the jury, but if you believe it is, then by the way, it's documented that could have gone off accidentally. Where does that get them? I mean, if this is a felony murder case, then anybody dies in the commission of a felony, which would have been the robbery of Jonathan Price and his wife.
Right.
You know, accidental discharge, does this really get the defense anywhere?
Look, this is her opportunity to cross-examine the state's expert. So she's going to, use her own shotgun approach. And clearly what she really needs in this case is her own expert to debunk, if she can do so, to debunk the conclusions reached by this particular expert. So again, you're looking at bullet casings and you're trying to say that this particular bullet came from this particular gun. The criticism, I think, and clearly one that I think is a fair criticism, is that why does it take so many years of experience to be able to connect those dots? It seems to me that, it's sort of like anything else in this world. If it's obvious, it's obvious. And if you need some specialized training that takes years to develop, then maybe it's not so obvious. And if it's not so obvious, maybe it's junk science.
Yeah, this is a big issue of debate in a lot of the cases we cover. But look, folks, we have a sidebar that's continuing along here. Not sure if it's just going to result in the end of the day or where we're going to go. So will we wait for things to pick up in court, or will we wait for them to officially break for the day? I want to review some of the previous testimony here. Shane Hansford was one of the critical witnesses for the state thus far. He was one of the people who was in that hotel room who was robbed and from whom a gun was stolen 6 days before the shooting of Jonathan and Megan Price. The link that they're trying to make here is that that stolen gun from the hotel room robbery is the gun that they have in their hands. And they're trying to say that, look, it's the gun that was used in the murder. We're thinking about going to that, but I want to keep a very close eye on court because this sidebar just wrapped up. It looks like we might be going back to testimony. Yes, we will. So let's go there first.